Chapter 9, School Regulations. 1. By whom made? In many of the states the statutes creating the boards of directors, trustees, or committees, expressly confer upon them the authority to make all needful rules for the regulation of the schools under their care and control. And the right to do so is undoubtedly to be implied where the statute gives the board the control and custody of the schools, while the principal or teacher of a public school is subordinate to the school board, or board of education of his city or district, and must enforce regulations adopted by it for the government of the school, and execute its lawful orders in that behalf. Yet, in matters concerning which the board has remained silent, he has authority, as in loco parentis, to enforce obedience to his lawful commands, subordination, civil deportment, respect for the rights of other pupils, and all obligations inherent in every school system, and constituting the common law of the school, which every pupil is presumed to know. In a proper case, and when not deprived of the power by the affirmative action of the board, such teacher has the inherent authority to suspend a pupil from the school, though such suspension, with the reasons therefor, should be promptly reported to the board. 2. By whom enforced? Since the regulations are made for the government of the school, and the school is under the immediate control and supervision of the teacher, the execution of the rules and orders of the directors necessarily devolves upon the teacher, and in the execution of proper rules he is not liable for any damages that ensue. 3. Regulations as to admission. Questions sometimes arise in respect to the authority of teachers and directors to refuse admission to the free public schools under certain circumstances. A principal of a public graded school may refuse a child admission as a pupil, provided such child has not education sufficient to enter the lowest grade of such school. Persons residing out of the state cannot send their minor children into it, and by any method give them a domicile in the state which shall entitle them to acquire an education in the public schools. Nor can parents entitle their children to the benefits of the common schools of an adjoining district by binding the children out as apprentices in such district for the sole purpose of sending them to school there. They would be trespassers and liable in damages to the district. Neither the teacher nor school board has authority to make any discrimination between children of different races. Persons of African descent cannot lawfully be denied admission to the common schools, and in most of the states they cannot be compelled to attend separate schools. Mandamus will lie to compel the admission of a child so excluded, and, although the proceedings are for the benefit of the child, the father is the proper party to make the application for the writ, he being the child's natural guardian, and charged with his education. The legally appointed guardian of such minor may also procure a writ for the same purpose. 4. Regulations as to attendance. It is competent for a board of school directors to provide, by rule, that pupils may be suspended from school if they shall be absent or tardy, except for sickness or other unavoidable cause, a certain number of times within a fixed period. Any rule of the school, not subversive of the rights of the children or parents, or in conflict with humanity or the precepts of divine law, which tends to advance the object of the law in establishing public schools, must be considered reasonable and proper. It requires but little experience in the instruction of children and youth to convince anyone that the only means which will assure progress in their studies is to secure attention, the application of the powers of their minds to the studies in which they are instructed. Unless the pupil's mind is open to receive instruction, vain will be the effort of the teacher to lead him forward in learning. This application of the mind in children is secured by interesting them in their studies. But this cannot be done if they are at school one day and at home the next, if a recitation is omitted or a lesson left unlearned, at the whim or convenience of parents. In order to interest a child, he must be able to understand the subject in which he is instructed. If he has failed to prepare previous lessons, he will not understand the one which the teacher explains to him. The rule requiring constant and prompt attendance is for the good of the pupil, and to secure the very objects the law schools has in view in establishing public schools. It is therefore reasonable and proper. It is required by the best interests of all the pupils of the school. Irregular attendance of pupils not only retards their own progress, but interferes with the progress of those pupils who may be regular and prompt. The whole class may be annoyed and hindered by the imperfect recitations of one who had failed to prepare his lessons on account of absence. The class must endure and suffer the blunders, promptings, and reproofs of the irregular pupil, all resulting from failure to prepare lessons which should have been studied when the child's time was occupied by direction of the parent in work or visiting. Tardiness is a direct injury to the whole school. The confusion of hurrying to seats, gathering together of books, etc., by tardy ones, at a time when all should be at study, cannot fail to greatly impede the progress of those who are regular and prompt in attendance. The rule requiring prompt and regular attendance is demanded for the good of the whole school. While it may be admitted that absence and tardiness are acts committed out of school hours, yet as their effects and consequences operate upon the school, the pupils when assembled for instruction, they are therefore subject to control by rules for the government of the school. If the effects of acts done out of school hours reach within the schoolroom during school hours, and are detrimental to good order and the best interest of the pupils, it is evident such acts may be forbidden. Truancy is a fault committed away from school. Can it be pretended that it cannot be reached for correction by the school board and teachers? A pupil may engage in sports beyond school that will render him unfit to study during school hours. Cannot these sports be forbidden? The view that acts, to be within the authority of the school board and teachers for discipline and correction, must be done within school hours, is narrow and without regard to the spirit of the law and best interest of our common schools. It is in conflict, too, with authority. See upon this point Lander v. Seaver, VT, 114, and Sherman v. Inhabitants of Charlestown, 8 Cush, 160. The doctrine we have above endeavored to sustain is, in these cases, distinctly announced. The rule in question, as we have shown, operates directly upon the order of the school, upon the pupils when assembled for instruction. It promotes efficiency of the school, and secures the progress of the pupils in their studies. It is, therefore, a rule for the government of the school, and must be regarded as proper and reasonable, and within the authority of the school officers to prescribe and enforce. Again, it is said that the rules visit upon the child punishment for the parent's offense. That is, the child is kept from school through the fault of the parent, and is punished for the act of the parent in detaining him. If the good of the children were to be considered only, there would be force in this argument, but it is completely answered by the consideration that the parent's act is an injury to the whole school. The child, through no fault of his own, or of his parents, may be afflicted with a contagious disease, yet, as the good of other pupils demand it, he may be for that reason forbidden attendance at school. Spear v. Cummings, 23 Pick, 225. The good of the whole cannot be sacrificed for the advantage of one pupil, who has an unreasonable father. Upon the parent must rest the great responsibility of depriving his child of the opportunities of education, which the laws of the state so generously offer. If the education of children were compulsory upon parents, who could be reached by proper penalties, as for an offense, for failure to send their children to school, in that case the child could be relieved from the hardship of expulsion, and the parent made responsible for his acts in detaining him from school. As the law now is, no other means can be devised for enforcing the rule requiring regular and prompt attendance, than the penalty of expulsion. In the case of James Ferreter et al. v. J. M. Tyler et al., in the Supreme Court of Vermont, the decision in which contains another exhaustive discussion of the power of the directors to prescribe the hours of attendance, etc. The complainants were members of the Catholic Church in the village of Brattleboro. On June 4, 1875, the priest of said church, acting for the complainants, sent to the respondents, who were the Prudential Committee of that school district, a request that the children might be excused from attendance at school on all holy days, and especially on that day, it being Holy Corpus Christi Day. The committee replied that the request could not be granted, as it would involve closing some of the schools and greatly interrupting others. It further appeared that about 60 Catholic children, by direction and command of their parents, were kept from school to attend religious services on the 4th of June, 1875, being, as stated in the bill, Holy Corpus Christi Day. All, or nearly all, applied either that afternoon or next morning, and were told by the committee that, as they had absented themselves without permission, and in violation of the rules of the schools, which they well understood, they could not return without an assurance from their parents or their priest that in future they would comply with the rules of the schools, at the same time assuring the children and many of their parents, and also the priest, that if the schools would not be again interrupted in like manner they would gladly admit said children to them, that the priest and parents refused, saying they claimed as a matter of right that they might take their children from the schools on all days which they regard as holy days. The bill asked an injunction to restrain the respondents from preventing the admission of the children to the schools. The court below dismissed the bill, and the Supreme Court, Barrett, J., delivering the opinion, affirmed the decree dismissing the bill. Judge Barrett places the decision upon the ground taken in the Iowa case previously quoted from, viz., that it is the right of the directors of the public schools to prescribe the hours of attendance of the pupils, to make a proper system of punishments, etc. In so doing the public rights and convenience must govern, without regard to the wishes, convenience, or private preferences of parents or others. This rule applies to the attendance of children on public or private religious worship on weekdays during the prescribed hours of school. Such purpose is no excuse for the violation of a rule of school. The following is quoted from the opinion: all are subjected alike to the law and its administration. The Methodist, who regards his camp meeting as demanding as much of his conscience as the Episcopalian does his Christmas or Lent. The Episcopalian, who regards the feast and fast days of his church as demanding as much of his conscience as the Catholic does his Holy Corpus Christi. The Congregationalist, and Presbyterian, and Baptist, and other sects, who care for none of these things, and whose prayer meetings and protracted meetings demand as much of their consciences as in the case of those before named, and the man of no preference and no religion, all and all their children are subjected alike to the school laws and to their administration. Let it be granted that parents and others may, upon their own respective reasons, control the attendance of the scholars, as against the official right of the committee in that behalf, and practically the ground of system and order and improvement has no existence. For the parents and guardians of the scholars may each on his own motion, and on his own notions, withhold their respective scholars from the schools. In this respect, so far as its effect on the schools is concerned, it makes no difference whether the occasion and motive involve conscience, will, whim, or the pocket. In Spear v. Cummings, Chief Justice Shaw says, the law provides that every town shall choose a school committee, who shall have the general charge and superintendence of all the public schools in such towns, and that this includes the power of determining what pupils shall be received and what pupils rejected. The committee may for good cause determine that some shall not be received, as, for instance, if infected with any contagious disease, or if the pupil or parents shall refuse to comply with regulations necessary to the discipline and good management of the school. A rule barring the doors of schoolhouses against little children coming from great distances in the winter, for being a few minutes tardy, is unreasonable and unlawful, as being in its practical operation little less than wanton cruelty. 5. Regulations as to the use of the Bible, etc. Perhaps no other question treated of in this volume has excited the interest, alarmed the understandings, or aroused the feelings of the people to such an extent, as the question whether the Bible should be read in our public schools or excluded therefrom. It must be borne in mind that the Constitution of the United States goes only to the length of ordaining that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Mr. Story says of this article, it was under a solemn consciousness of the dangers from ecclesiastical ambition, the bigotry of spiritual pride, and the intolerance of sects, exemplified in our domestic as well as in foreign annals, that it was deemed advisable to exclude from the national government all power to act upon the subject. The situation, too, of the different states equally proclaimed the policy as well as the necessity of such an exclusion. In some of the states Episcopalians constituted the predominant sect, in others, Presbyterians, in others, Congregationalists, in others, Quakers, and in others, again, there was a close numerical rivalry among contending sects. It was impossible that there should not arise perpetual strife and perpetual jealousy on the subject of ecclesiastical ascendancy, if the national government were left free to create a religious establishment. The only security was in extirpating the power. But this alone would have been an imperfect security, if it had not been followed up by a declaration of the right of the free exercise of religion, and a prohibition, as we have seen, of all religious tests. Thus the whole power over the subject of religion is left exclusively to the state governments, to be acted upon according to their own sense of justice and the state constitutions, and the Catholic and the Protestant, the Calvinist and the Armenian, the Jew and the infidel, may sit down at the common table of the national councils, without any inquisition into their faith or mode of worship. Story on the Constitution, Seconds. 1879. No inhibition is laid upon the states, but by the compacts under which some of the newer states were admitted into the Union they were required to provide by an ordinance irrevocable, without the consent of the United States and the people of the state, that perfect toleration of religious sentiment shall be secured. Apart from these few exceptions, it is left entirely optional with the states to pass any law respecting religion not inconsistent with the constitution of the state by which such law is adopted. The state constitutions, however, contain the same principle, but differently expressed. No general rule can be laid down which shall apply with critical accuracy to each of the states. But it is safe to say, from an examination of the state constitutions, that they do not go to the length of ostracizing the Bible, and do not necessarily exclude the Bible from the public schools. A stranger to our institutions might reasonably infer, from much of the public discussion of the question, that our public schools are hotbeds of sectarian religion, in which the consciences of some of the children are continually suffering violence and persecution. Such a thing as sectarian teaching, or the teaching of any religion as religion, or of any irreligion, is in fact unknown to the public school system. It is the custom in many of the public schools to open the exercises of the day with reading a few verses of the Bible without note or comment. In some of the large cities, this custom has been abandoned by the school boards. The whole subject is usually left to the discretion of the board of directors, as are their rules prescribing studies, etc. Where the law leaves such a discretion with the board, as it generally does, the courts have refused to restrain, coerce, or interfere with such discretion. No court of last resort has ever held that a rule adopted by a public school board, requiring that the Bible should be read in the schools under its charge, is unconstitutional. On the contrary, it has been held by the highest courts in several of the states that such a rule is entirely proper and not unconstitutional. It has been decided that a rule requiring every pupil to read a particular version of the Holy Bible, though it may be against the conscience of some to do so, violates neither the letter nor the spirit of the Constitution of Maine. It was held in Massachusetts that a school committee of a town has the legal power to pass a rule requiring a school to be opened by reading from the Bible and prayer every morning, and that each child shall bow the head during such prayer, and that any pupil shall be excused from bowing the head whose parents request it, and where any pupil refuses to obey the rule, and his parents refuse to request that he shall be excused, the committee may expel such pupil from the school. In 1870 arose the case of the Board of Education of Cincinnati v. Minor, involving the question of the right of the board to prohibit the reading of religious books, including the Holy Bible, in the public schools of Cincinnati. The Superior Court of that city granted a perpetual injunction restraining the board from carrying out its prohibition. The majority opinions were delivered by Judges Huggins and Storer, and Judge Taft delivered a dissenting opinion. The Board of Education appealed the cause to the Supreme Court of Ohio, and that court in 1872 held that the management of the public schools being under the exclusive control of directors, trustees, and boards of education, the judicial power will not direct what instruction shall be given, or what books shall be read therein. This case created great interest, and the discussion in the Superior Court of Cincinnati and in the Supreme Court of Ohio is perhaps the most exhaustive discussion extant on the subject. The Supreme Court of Illinois has recently decided a similar case. The suit was an action on the case brought by Edward McCormick against Cora Bett and the directors of the school she was teaching, to recover damages on account of his suspension by the directors from the benefits of the school, for the non-observance of a rule adopted by them for the government of the school. The rule provided that the teacher might read as an opening exercise every morning, not occupying more than 15 minutes, a chapter from the King James translation of the Bible. No one was required to be present at such exercise unless he chose to do so, and while such exercise was being conducted every pupil was required to lay aside his books and remain quiet. The plaintiff refused to obey the rule, and for the non-observance of the rule, which he claimed was void as interfering with the religious convictions of himself and his father, he was suspended from all the rights and privileges of said school until he should express a willingness to comply with the rule. Section 48 of the Illinois School Law makes it the duty of the directors to adopt and enforce all necessary rules and regulations for the management and government of schools. To direct what branches of study shall be taught, and what textbooks and apparatus shall be used in the several schools. The court held that under this section the directors exercise judgment and discretion in the expulsion or suspension of a pupil for refusal to obey proper rules and regulations, and that they are not liable in damages for the expulsion or suspension of a pupil, where they act in good faith, and not wantonly or maliciously. Thus the tendency of the ablest judicial decisions is to view favorably those statutes which entrust the control of the schools and the selection of textbooks and studies to the local school boards to be regulated according to the wants of the community, and where there is no statutory or constitutional provision to the contrary, and the general management of the schools is entrusted to the various school boards, such boards would, under the authorities, have the right to prescribe, or to prohibit, the use of the Bible and the Lord's Prayer. Speaking on the subject of religious liberty and equality, Mr. Cooley says, but while thus careful to establish religious freedom and equality, the American constitutions contain no provisions which prohibit the authorities from such solemn recognition of a superintending providence in public transactions and exercises as the general religious sentiment of mankind inspires and as seems meet infinite and dependent beings. Whatever may be the shades of religious belief, all must acknowledge the fitness of recognizing in important human affairs the superintending care and control of the great governor of the universe, and of acknowledging with thanksgiving his boundless favors, at the same time that we bow in contrition when visited with the penalties of his broken laws. No principle of constitutional law is violated when Thanksgiving or fast days are appointed, when chaplains are designated for the Army and Navy, when legislative sessions are opened with prayer or the reading of the scriptures, or when religious teaching is encouraged by exempting houses of religious worship from taxation for the support of the state government. Undoubtedly the spirit of the Constitution will require, in all these cases, that care be taken to avoid discrimination in favor of any one denomination or sect, but the power to do any of these things will not be unconstitutional simply because of being susceptible of abuse. In New Jersey the statute makes lawful the reading of the Bible and the use of the Lord's Prayer in the public schools of that state. In Indiana, Iowa, Louisiana, and Mississippi, it is enacted that the Bible shall not be excluded from the public schools. In Iowa and Louisiana it is added that no child shall be compelled to read it contrary to the wishes of his parent or guardian. In conclusion it may be laid down, 1. That under the constitutions of the American states sectarian or denominational religious teaching in the public schools is not only improper but unlawful. 2. That where a school board is charged with the control and regulation of public schools and of the studies and textbooks used therein, it is proper and lawful for such school board to prescribe the reading of the Bible, without note or comment, as an exercise in such schools. 6. Regulations as to studies. A rule prescribed by a board of education, that a pupil failing to come prepared with a required exercise or with a reasonable excuse shall be suspended, is a reasonable rule, such as the board has authority to adopt. A requirement by a teacher of a district school, that the pupils studying grammar shall write English composition, is a reasonable rule, and refusal to comply therewith, in the absence of a request from the parents that he be excused therefrom, will justify expulsion of the pupil from school. No parent can insist that his child shall be placed or kept in particular classes, when by so doing others will be retarded in their studies, or that his child shall be taught studies not in the prescribed course of the school, or be allowed to use a textbook different from that in use in the school, or that he shall be allowed to adopt methods of study that interfere with other pupils in their studies. If a study has no connection with the studies which a pupil wishes to pursue, it can make no difference to the other pupils, or those in charge, whether such pupil undertake that study or not, and if such a study is interdicted by the pupil's parent, the child should be admitted to advanced standing, along with his class or grade, if he passes a satisfactory examination of the other studies in his class. There are several cases which seem to hold that a teacher cannot punish nor the directors or trustees expel a pupil for refusing to pursue any study not prescribed by law, and from which the parents or guardian request that the child be excused. But where the study from which the parent wishes the child to be excused is one in which the child must necessarily acquire some proficiency before it can pursue other studies in a course, it may well be said that none of the decisions above referred to negative the idea that the child might be denied entrance to such advanced class. While parents may have the right to say that their children shall not pursue particular studies not prescribed by law, yet the school must not be burdened and annoyed by irregular study, and proficiency in one study may be a requisite for admission to another of the same course. Where such study is not connected with the studies to be pursued, and proficiency in it is not requisite in order to pursue other studies in the same course, then it seems the parents have a right to prohibit such study, and the child cannot lawfully be whipped, expelled, or refused advanced standing, solely because of his refusal to pursue such study. 7. Regulations as to conduct, etc. The General School Committee of a town has power to exclude therefrom a child of immoral or licentious character, though such character be not manifested by any acts in the schoolroom. This was held in a case in which there was no prescribed rule on the subject. Chief Justice Shaw says, "It seems to be admitted, if not it could hardly be questioned, that for misconduct in school, for disobedience to its reasonable regulations, a pupil may be excluded." Why so? There is no express provision in the law, as it then was, authorizing such exclusion. It results by necessary implication from the provision of law requiring good discipline. It proves that the right to attend is not absolute, but one to be enjoyed by all on reasonable conditions. Again, but the court are of opinion, that a power is vested in the General School Committee, or the master with their approbation and direction, to exclude a pupil, for good and sufficient cause. It is undoubtedly true that trustees or committees have the power, and it is their duty, to dismiss or exclude a pupil from their school when, in their judgment, it is necessary for the good order and proper government of the school so to do. They may do so to prevent a pupil from bringing contagion into a school. It has even been held that the teacher may, when necessary to maintain proper discipline in school, expel a pupil, and if the prudential committee insist upon the return of such scholar to school when his presence would be fatal to the maintenance of discipline, the teacher may lawfully quit the school and yet recover wages up to the time she quit. But the case in which this was decided was an aggravated one, and the decisions of other states do not warrant the teacher in going so far. It is better merely to suspend the pupil, and report the matter to the board for such further action as may seem fit. The school authorities have a right to exclude from their grounds or buildings anyone who enters therein to disturb the peace or interfere with the legitimate exercises of the school. Where a member of the district school committee was present at the opening of school for the day, and one of the larger boys of the school addressed him, in the presence of other pupils, in a profane and insulting manner, and such committee man ordered the boy out of the room, and, on his refusing, put him out by force, using no more force than was necessary, the committee man was justified in so doing. In most of the states there is a statute making it a criminal offense for anyone willfully to disturb or interrupt any school or religious meeting. In case anyone should willfully disturb or interrupt the school, it would be proper for the teacher or anyone cognizant of the facts to lodge a complaint against the offender before a justice of the peace. 8. General Principle. The general principle running through all of these decisions is that the directors or trustees, as the case may be, have the power and authority to promulgate and enforce such orders, rules, and regulations as are not subversive of the legal rights of the parents or children, or in conflict with humanity and the principles of divine law, and which tend to advance the object of the law in establishing schools, and that whatsoever has a direct and immediate tendency to injure the school in its important interests, or to subvert the authority of those in charge of it, is properly a subject for regulation and discipline, and this is so wherever the acts may be committed. There is, nevertheless, a limit to the powers of the school directors, and that limit is the needfulness or reasonableness of the rule. A board of directors having made a rule that no pupil should, during the school term, attend a social party, the plaintiff, a pupil of the school, violated the rule, and was expelled from school for so doing, it was held that under the law the board had power to make needful rules for the government of pupils while at school, but no power to follow them home and govern their conduct while under the parental eye, and that in prescribing the rule it had gone beyond its powers. The Wisconsin court has thrown out a suggestion which teachers may profitably heed, and that is that the directors are the prime rule makers for the schools under their control. It is always well for a teacher to suggest any matter of regulation to the board where there is sufficient time to do so, and they should bear in mind that while they may, when necessary, make rules in the absence of any established by the board, yet their power is in this respect limited, and the law comparatively unsettled. Whenever it is necessary for a teacher to act at once in order to maintain order and discipline, and to protect the schools from the misconduct of a pupil, the teacher is doing his duty and right by suspending such pupil, and he is justified in doing this without waiting for an order of the directors. Neither the teacher, with a legal certificate of qualifications and lawfully employed, nor the board of school directors or trustees, are liable in damages for tort by reason of having expelled a child from school, so long as they act in good faith. If they are in good faith in the discharge of their duties they are not liable. It has been said that to make either liable there must be malice, willfulness, or an evil mind bent on mischief, but this may be inferred from the acts. Nor is the teacher who suspends or expels a pupil liable on an implied contract to teach. There is no implied contract between teacher and pupil in our public schools that the former shall teach the latter. The only contract of the teacher is with the board of directors employing him, and he is accountable to the board alone for his acts as teacher, unless he is stirred by malicious motives, and thus renders himself amenable to the law. The parent cannot limit the teacher's authority over the pupil, nor deprive him of it except by removing the child from the school.